records request to the city of Forney for a complete roster of uniformed officers, including names and badge numbers, and vehicles to which they are assigned. They cited the law enforcement exemption, which is Texas Government Code 552.108, subsection B1, which is the law enforcement exemption. They go on to say that shift changes have been cited as an example of the type of information that is exempt from disclosure. And they provided this case law, Fort Worth v. Cornyn. And here's some language from that case law. It reveals that the type of internal records that could interfere with law enforcement are those that would divulge a police department's methods, techniques, and strategies for preventing and predicting crime. V. Cornyn. Decided 2002. And if you're interested in public records law and public records requests, specifically in Texas, this may interest you because this appeal in a declaratory judgment action presents the issue of whether Section 552.108, subsection B1 of the Texas Public Information Act authorizes the city of Fort Worth to withhold from an individual seeking as a position as a police officer background and reference information it obtains from third parties as part of its evaluation of his employment application. See Texas Government Code N 552.108B1. Excuse me. We hold that Section 552.108B1 does not permit the city to withhold such documents from a police officer applicant making a valid disclosure request under the Act. In so holding, we overrule appellant's sole issue and affirm the judgment of the district court. Factual and procedural background. The events giving rise to this suit stem from the city of Fort Worth's response to Frederick Tiede's application for employment as a police officer. After conducting a background investigation, administering tests to, and interviewing Tiede, the city notified him of its decision not to hire him as a police officer. Thereafter, Tiede submitted an open records request to the city asking for copies of any documents or information to which I am entitled for the purpose of discovering the basis of your determination regarding my application with the Fort Worth Police Department. Believing the information to be exempt from disclosure, the city requested a decision from the Attorney General regarding whether the applicability of Section 552.108 of the Texas Government Code, the Texas law enforcement exemption, which permits the government to withhold internal records that relate to, and, if released, would interfere with law enforcement. See also State Statute 552.301, subsection A, a governmental body that receives a written request for information that it wishes to withhold from public disclosure and that it considers to be within one of the exceptions under the Act, must ask for a decision from the Attorney General about whether the information is within that exception. Right, so that's why we're seeing letters to the Attorney General whenever we do a records request. They have to submit it to the Attorney General because they want to withhold the information. They don't want to provide the information, and they think that they can hide it under one of the exemptions under the Act. The Attorney General issued an informal letter ruling stating inter alia that Section 552.108, subsection B1, did not apply to documents containing information relating to the city's investigation into an applicant's fitness for being a police officer. Texas Attorney General Open Records Decision 2784 of 1999. Excuse me. The Attorney General advised the city that it could not withhold from the rejected applicant the information he requested. Pursuant to Section 552.324 of the Public Information Act, the city filed a declaratory judgment action in district court challenging the Attorney General's ruling. See Government Code and 552.324. Before the district court, the city took the position that the information it obtained in connection with evaluating Tiede's application for employment as a police officer constituted internal records of the police department. The city asserted that because it maintained such records for internal use in matters relating to law enforcement, i.e., selecting the most highly qualified individuals to detect, investigate, and prosecute crime, the records were exempt from the Act's disclosure requirements. See 552.108b. Both parties filed summary judgment motions. The district court rendered judgment denying the city's motion and granting the Attorney General's. On appeal to this court, the city challenges that judgment. Okay, so the first section we've learned that the case is about an applicant, someone who applied for a job as a police officer at the city of Fort Worth, and after they conducted background checks and interviews, denied him a job. He subsequently thereafter conducted a records request for any records that might be relevant to their decision. Fort Worth did not want to provide this information about the background checks that they conducted on this applicant. And after the Attorney General made his decision that said that this information was not exempt, well, they wanted to appeal his decision because they did not want to provide this information. So let's continue. Standard of review. The city's appeal does not raise factual issues about the nature of the information sought. Therefore, the question before this court is one of law, which we review de novo, which means again or anew. See City of Garland v. Dallas Morning News, 2000. Natividad v. Alexis, Inc., 94. On cross motions for summary judgment, each party bears the burden of establishing that it is entitled to judgment as a matter of law. See Guinness v. Galveston County, 93. When the district court grants one party's motion and denies the others, the reviewing court should determine all questions presented and render the judgment that the court below should have rendered. See Commissioner's Court v. Agon, 940, Texas 97. If the district court fails to specify the grounds for granting summary judgment, the reviewing court must affirm the district court's judgment if any of the grounds asserted by the prevailing party are meritorious. FM Props Operating Co. v. City of Austin, Texas 2000. Here, although the district court did not specify the grounds on which it rendered judgment, because the Attorney General's motion is based only on the law enforcement exception, we must affirm the judgment only if that argument has merit. City of Houston v. Clear Creek Basin, Auth. 1979. Arlington Independent School District v. Texas Attorney General, Texas Appellate, Austin, 2001. Which brings us to part 3, the analysis. A. The controversy. On appeal, the city's only contention is that items dealing with the confidential character recommendation letters and confidential background information obtained from third parties are exempt from disclosure under the law enforcement exemption 1. The crux of the city's argument is that because it must make prudent, informed decisions regarding its initial determination of whether to hire a police officer applicant, the information it obtains from third parties in furtherance of that objective is related to law enforcement. The city then contends that disclosing such information to the applicant requestors would discourage third parties from providing candid evaluations of applicants, without which, the city asserts, it could not properly evaluate an applicant's qualifications. Therefore, argues the city, the requested information is exempt from disclosure pursuant to Section 552.108, subsection B1, 2. The Attorney General disagrees, asserting that the law enforcement exception does not apply to administrative records that relate solely to the city's hiring process for a police officer. To fully understand the merits of the parties' respective arguments, we begin with a brief history of the Texas Public Information Act. Texas Public Information Act. Using the Federal Freedom of Information Act as a model in 1973, the Texas legislature enacted the Texas Open Records Act, now known as the Texas Public Information Act. The effect of the TPIA is to permit private citizens to obtain documents held by governmental entities and officials. See generally Texas Government Code N 552.001 through .353. In clear and unequivocal language, the TPIA mandates that each person is entitled, unless otherwise expressly provided by law, at all times to complete information about the affairs of government and the official acts of public officials and employees. 552.001a. This notion of full disclosure is premised on the basic principle that government is the servant and not the master of the people. And to retain control over the government that they created, the people must remain informed. Yeah, that right there, that's a good little morsel. That kind of sums up like the whole premise of the basic principle that government is the servant and not the master of the people. People need to learn that or remember that these days. And to retain control over the government they created, the people must remain informed. The statute's intent to prevent the government from withholding all but the most sensitive documents is evidenced by the legislature's directives in Section 552.001, requiring courts to liberally construe the TPIA in favor of granting a request for information, and Section 552.006, providing that the Act does not authorize the withholding of public information or limit the availability of public information to the public as expressly provided. To withhold information, a governmental body must establish that the requested information is not subject to the Act, or withholding the information is permitted by one of the TPIA's enumerated exceptions to the disclosure. See Thomas v. Cornyn. Holding government, not the requester, must produce evidence that an exception to disclosure applies. Whether information is subject to the Act and whether an exception to disclosure applies are questions of law. A&T Consultants v. Sharp, Texas 95. Here, the parties do not dispute that the requested documents are public information as defined by the Act. Rather, the only question is whether the city may withhold that information pursuant to Section 552.108b1. The law enforcement exception. The law enforcement exception contains three subsections, A through C. The specific provision at issue in this appeal is subsection B1, which provides an internal record or notation of a law enforcement agency or prosecutor that is maintained for internal use in matters relating to law enforcement or prosecution is accepted from the requirements of disclosure if release of the internal record or notation would interfere with law enforcement or prosecution. The parties do not contend that this provision is ambiguous. Rather, each party maintains that the other's interpretation of the statute is contrary to its plain language and the legislative intent. Yeah. That's a good way of putting it. To interpret this provision, we adhere to the well-settled principles of statutory construction. In applying the plain and common meaning of a statute, a court may not, by implication, enlarge the meaning of any word in the statute beyond its ordinary meaning, especially when the court can discern the legislative intent from a reasonable interpretation of the statute as it is written. Courts should be careful not to give one provision a meaning out of harmony or inconsistent with other provisions, although it might be susceptible to such a construction standing alone. To be sure, a court must presume that the legislature intends an entire statute to be effective and that a just and reasonable result is intended. Thus, even when a statute is not ambiguous on its face, a court may consider numerous factors to determine the legislature's intent, including the object sought to be obtained, the circumstances of the statute's enactment, the legislative history, the common law or former statutory provisions, including laws on the same or similar subjects, the consequence of a particular construction, the administrative construction of the statute, and the title, preamble, and emergency provisions. The plain language of Section 552.101, subsection B, subsection 1, sets forth three requirements that must be met to withhold information under that provision. So you have three requirements. The information must be an internal record or notation maintained for internal use relating to law enforcement and, if released, interfere with the law enforcement. Texas Government Code 552.108b1. Because the parties do not dispute that the requested documents are maintained for internal use, we focus on whether they relate to and their release would interfere with law enforcement. The city urges us to follow a federal court of appeals opinion that found that information obtained as part of a pre-employment background investigation was related to law enforcement and therefore exempt from disclosure. See Middleman v. Office of Personnel Management, 1996. In Middleman, the court began its analysis with a discussion of the federal law relating to background investigations, noting that such investigations were authorized by executive order, as well as other provisions of federal law, to ensure that employing the person being investigated was clearly consistent with the interest of national security. End quote. Next, the court noted the multi-purpose objectives behind background checks, namely to ensure that a prospective employee is not ineligible for the position as a result of prior violations of the law, and discovering past conduct that could affect his ability to fulfill the position's requirements. Finally, the court reasoned that because enforcement of the law fairly includes not merely the detection and punishment of violations of law, but their prevention, background investigations were related to law enforcement. Giving due consideration to the distinctions between the Freedom of Information Act and the TPIA and the paucity of the Middleman Court's analysis, we conclude that the present case is sufficiently distinguishable from Middleman to warrant a contrary result. See Holmes v. Morales, 96, when the Texas Legislature used the FOIA as a model for the Texas Open Records Act. It appears to have intentionally declined to limit its law enforcement exception in the manner the United States Congress chose. In reaching its decision, the Middleman Court failed to consider the history or purpose of the FOIA and was further influenced by its consideration of other federal law concerning background investigations. Additionally, the court offered no support for its holding, other than a conclusory assertion that because law enforcement encompassed the prevention of crime, background investigations conducted to assess an applicant's qualification must relate to law enforcement. We are not persuaded by such reasoning. Unlike its federal counterpart, the TPIA contains a strong statement of public policy favoring public access to governmental information and a statutory mandate to construe the act to implement that policy and to construe it in favor of granting a request for information. City of Garland. The singularity of the TPIA alone warrants our decision to depart from the Middleman Court's reasoning. In its brief, as in the court below, the city relies on Fort Worth Police Chief Ralph Mendoza's affidavit to establish that the requested documents are exempt from disclosure. Chief Mendoza's affidavit, however, is conclusory and fails to explain either how the requested information relates to law enforcement or in what manner releasing such information would interfere with law enforcement. Mendoza asserts that the records at issue are records or notation maintained by the Fort Worth Police Department for internal use in matters related to law enforcement. They relate to a civil investigation of a potential police officer and were developed and maintained only for use in an internal hiring decision. None of Mendoza's statements, however, support the conclusion that the requested documents relate to law enforcement as the term is commonly understood. The city, admittedly, conducts its civil investigation not in its official capacity as the Fort Worth Police Department acting under the color of law, but as a potential employer. We do not believe that the legislature intended Section 552.108 to permit a police department to withhold information related solely to its hiring decisions. Instead, the exception evidences the legislature's recognition of the peculiar considerations release of internal police records could have on a police department's ability to enforce the law. See Texas Attorney General Open Records Decision 287, 1981, stating that the law enforcement exemption was not intended by the legislature to shield from public view information in the hands of police units that would ordinarily be available to the public if possessed by a different governmental unit. When a police department acts as an employer, its concerns are similar to those of other governmental agencies to hire the most qualified applicants, and when acting in such a capacity, its activities do not, quote, relate to law enforcement, end quote. That there may be incidental effects stemming from an initial hiring decision is insufficient. We believe to warrant a strained reading of Section 552.108 that would result in denying an applicant requester information not clearly specified by that exception. To find otherwise would also be inconsistent with the legislature's directive to liberally construe the act in favor of disclosure. Further, to conclude that the requested information is exempt from disclosure, we would be ignoring the special purpose behind the law enforcement exception and would bestow upon police departments a withholding privilege not available to any other government employer. Accordingly, we cannot say that the background and reference information obtained from third parties in the ordinary course of conducting a background investigation is related to law enforcement. Nor can we conclude that such information would, if released, interfere with law enforcement. To establish this element, the city again refers us to Mendoza's affidavit, in which he avers release of this type of information will deprive the Fort Worth Police Department of the ability to hire the best candidates for its police force because it would have a chilling effect on citizens who would be willing to comment on an applicant only if their identity was kept confidential. While this statement may well be true, we cannot say that the release of background and reference information obtained from third parties would have any effect on the city's ability to enforce the law, at least not in the manner contemplated by the legislature in enacting Section 552.108. Hubert Harthank's text newspapers, Austin 1983, referenced rejecting argument that qualified candidates for university administrative positions would be discouraged from applying for a position if they thought their names might be disclosed, and stating, quote, while this factor might persuade the legislature to create an Open Records Act exception for such applicants, it is not evidence of a clearly unwarranted invasion of personal privacy under the Open Records Act. A more reasonable interpretation of the statutory language reveals that the type of internal records that could interfere with law enforcement are those that would divulge a police department's methods, techniques, and strategies for preventing and predicting crime. See A&T Consultants, Inc., 678. Examples of these types of documents include police officer training guides, policy and procedure manuals, shift change schedules, and so there's where it mentions the shift change schedules as being the type of information that is exempt. Security details and blueprints of secure facilities. Well, yeah, that's the one we just read about in the Open Records Decision 413. Blueprints of the secure facilities and shift change schedules, which is something that I did not request. All I requested was vehicle assignments and names and badge numbers. All right, so Attorney General 2001 Policy and Procedure Manuals. Open Records Decision 413, yeah, 1984. Security details at execution. Yeah, because they wanted a blueprint of a secure facility. Releasing these types of documents would make available information that would make it more difficult for police officers to perform their mission. So they're trying to say that if they would give me the vehicle assignments, it would be the same as giving me their shift change, and it would make it more difficult for them to perform their mission. And we're going to get to see what the Attorney General decides on that. To continue. Absent clear and unequivocal language to the contrary, we may not presume that the legislature intended to include within the scope of Section 552.108 as information relating to law enforcement, background, and reference information obtained from third parties as part of the city's application review process. Were we to interpret Section 552.108b1 to include pre-employment background and reference information obtained from third parties, we believe we would be extending beyond permissible bounds the statute's plain language. In three separate instances, the statute links the words law enforcement and prosecutor. See Texas Government Code 108b1. The doctrine of construction non sequitur, a solcis, teaches that the meaning of particular terms in a statute may be ascertained by reference to words associated with them in the statute, and that where two or more words of analogous meaning are employed together in a statute, they are understood to be used in their cognate sense, to express the same relations and give color and expression to each other. Under this rule of construction, we construe the phrases information relating to law enforcement and would interfere with law enforcement in reference to the type of information that would also relate to prosecution or interfere with prosecution. So doing, we conclude that the phrase law enforcement, in light of the immediately following words prosecutor or prosecution, evidences an intent by the legislature to include within the law enforcement exception only that type of information that relates to violations of the law. So, vehicle assignments aren't really don't have to do with the violation of the law. If instead of limiting the scope of the law enforcement exception as we do, we accepted the city's argument that any activity engaged in by a police department is exempt from disclosure under Section 552.108, we would allow the exception to swallow the rule. See City of Garland. Because everything a police department does arguably involves law enforcement, were we to adopt the city's interpretation, none of a police department's records would be subject to disclosure. See Open Records Decision 287. In one sense, any information that a law enforcement agency possesses may someday become useful to it in the discharge of its law enforcement duties. The more reasoned approach, and the one we adopt, limits Section 552.108b1 to that type of information which, if released, would permit private citizens to anticipate weaknesses in a police department, avoid detection, jeopardize officer safety, and generally undermine police efforts to effectuate the laws of this state. Although the term law enforcement is not statutorily defined, it is commonly understood to contemplate a state official acting under the color of law. Thus, construing Section 552.108 as a whole, we believe that Section 552.108b1's relating to law enforcement requirement evidences an intent by the legislature to exempt from disclosure documents that facilitate a police department's ability to actively anticipate, plan for, and react to violations of the law, not information obtained from third parties as a result of pre-employment investigation. And so going back up here where it said, it limits 552.108 to that type of information which, if released, would permit private citizens to anticipate weaknesses, avoid detection, jeopardize officer safety, and generally undermine. And that right there is why this case law that we're reading right now explains why they're going to have to give me, fork over the records that I asked for. Because knowing their vehicle assignments is not going to undermine police efforts. I mean, it's pretty bad if it does. But, I mean, the most they're going to have to do is redact the shift change information, which I didn't want anyway. Reading on, our conclusion gives effect to, but does not infringe upon, the other two categories of information accepted by subsections A and C, and is supported by numerous Attorney General opinions interpreting the scope of Section 552.108. Although Attorney General opinions are not binding on this court, we consider them persuasive authority and accordingly give them due consideration. Arlington Independent School District. We find particularly instructive a 1983 Attorney General ruling construing the forerunner of Section 552.108 to require disclosure of information compiled by the Harris County Sheriff's Department as part of its background investigation of an applicant. Texas Attorney General Open Records Decision 361, 1983. In that case, the Sheriff's Department resisted disclosure, asserting that the information was related to law enforcement because the background information might reveal, quote, any problems a person might have in fulfilling his employment responsibilities. As in this case, the Sheriff's Department argued that releasing the information would discourage other people from coming forward with similar information in the future. Rejecting both the arguments, the Attorney General determined that the law enforcement exception did not authorize the Harris County Sheriff's Department to withhold the results of its background investigation. In addition to Open Records Decision 361, there are numerous Attorney General opinions similarly construing the scope of the law enforcement exception. 2001 findings, Section 552.108, exempted from disclosure policy and procedure documents, but not a police department's internal administrative investigations not involving an investigation of a crime. Internal administrative investigations not involving an investigation of a crime. Texas Attorney General Open Records Decision 531, 1989, holding that detailed use of force guidelines were exempt from disclosure because disclosure would interfere with law enforcement and crime prevention. Open Records Decision 456, 1987, explaining that the law enforcement exception protects information which, if revealed, might endanger the life or physical safety of law enforcement personnel. Open Records Decision 71 from 1986. The public has an obvious interest in having access to information concerning the qualifications and performances of governmental employees, particularly employees who hold positions as sensitive as those held by members of a sheriff's department. That the legislature has had numerous opportunities to address the Attorney General's construction of the Act but has failed to do so adds to the persuasiveness of these opinions. The Act was intended to provide the public with broad access to government documents. The Act includes specific language directing courts and government agencies to liberally construe its provisions in favor of disclosure. It also provides that the government may not withhold information unless an express provision of law authorizes it to do so. Texas courts, have consistently adhered to these requirements by narrowly construing the type of information that may be withheld under the statute's exceptions. Following this precedent, we hold that Section 552.108, subsection B.1, does not exempt from disclosure to an applicant requester documents obtained by a police department from third parties for the sole purpose of evaluating an applicant's qualifications. While it is clear that the law enforcement exception evidences an intent by the legislature to permit government agencies to withhold internal documents that would enable citizens to circumvent policies, procedures, and techniques used by police departments in carrying out their missions, we are certain that it was not intended to prevent an applicant requester from obtaining information provided by third parties that is unrelated to the actual enforcement of the law, i.e., information the city uses for the sole purpose of evaluating the applicant's fitness for employment. See Ken Petroleum Corp. Thus, we hold that the law enforcement exception does not permit the city to withhold from an applicant requester background and reference information it obtained from third parties to aid in the determination of whether to hire the police officer applicant. We overrule the city's sole issue. Conclusion. The Texas Public Information Act does not authorize the withholding of information from the public except as expressly provided. Having determined that Section 552.108, subsection B, subsection 1, does not exempt from disclosure to an applicant requester background and reference information obtained from third parties solely to aid police department in its hiring decisions, we overrule the city's sole issue and affirm the judgment of the district court.